In recent decades, there have been a number of high-profile court cases opposing farmers to Monsanto, and these cases are about the rights of farmers to save seeds for replanting. Now, these court cases have led to precedent-setting decisions that have considerably expanded corporate rights over seeds and conversely restricted farmers' rights to save seeds for replanting. Now, less well-known are a number of recent cases in countries of the Global South involving a similar set of issues. And I was interested in finding out how these court cases would be dealt with in the courts, given that these countries have different legislation, they have different legal cultures, and of course they also have different agricultural systems and practices. So my name is Karine Peschard, and I'm a researcher at the Graduate Institute and at the Geneva Academy. So the book is based on three legal controversies. The first one is a class action lawsuit that was filed back in 2009 by a farmers' union. And in this lawsuit, farmers challenged Monsanto's new practice of charging royalties on harvested soybean as opposed to charging royalties on the sale of seeds. The second case study is a tug-of-war, also in India, around royalties and patents for Bt cotton. And that dispute opposes farmers, seed companies, Monsanto, and the Indian government. And the third case study, also in India, involves accusations of biopiracy in the development of Bt brinjal, as eggplant is known in India. So by drawing on three prominent legal cases and on close to 90 interviews with a wide range of actors that are involved in these lawsuits, so from small farmers and large farmers to civil society representatives, corporate lawyers, civil servants, I'm able to draw a number of conclusions around the role of private actors and governments in the implementation of new legal regimes in agriculture, but also the role of litigants and legal activists in challenging and shaping these regimes. So when I was just starting this research in 2015, the Times of India revealed that first generation Bt cotton had never been patented in India, and that was 13 years after its commercial introduction. As incredible as this may seem, there was in the early years after the introduction of biotech crops in these countries, very few people knew which patents covered the technology. So intellectual property was a black box, and corporations essentially had a free hand. So Monsanto, for example, charged 75% royalties on first generation Bt cotton in India, despite the fact that they did not hold an Indian patent on the Bt trait. In Brazil, Monsanto continued to charge royalties on Roundup Ready soybean for 2.5 years after the expiration of its patent. So in this context, lawsuits have played a key role in clarifying the patent situation, and in doing so, they've raised a number of issues concerning the patents themselves and also corporate IP practices more broadly. One of the key arguments I made in the book is that the private IP systems that were put in place to collect royalties on biotech crops have ensured that corporations enjoy the same level of IP protection in countries like Brazil and India as they do in the US. And this despite the fact that these countries have different patent laws, they have different plant variety protection laws, and also different laws concerning farmers' rights. In this context, legal activism has played a key role in bringing the courts to examine the legality of these patents in the context of their own country's legislation. And while court decisions have gone both ways, some of these rulings have started to open cracks in dominant legal interpretations. If there is one takeaway from this research and from the book, it is that we tend to take patents for granted and not to question them because we think of them as technical objects, while what these legal challenges reveal is that they're in fact deeply political. These legal challenges show just how controversial patents on life forms continue to be in many countries today, that many of the issues they raise have yet to be settled, and that there is space for alternative legal interpretations when it comes to private IP rights on the one hand, and on the other, the rights of farmers, the right to food, and the public interest. So I'm now starting to work on a new project with the Geneva Academy of International Humanitarian Law and Human Rights on rights to seeds in Europe in context of the revision of the EU seed legislation. If you'd like to find out more about this project, you can check my page on the website of the Geneva Academy.